So homelessness has been a hot button issue nationwide, as obviously seen by a case hitting SCOTUS and being up for discussion over there this past week. From New Hampshire Bulletin, this is from State's Newsroom, actually, the national office for them. U.S. Supreme Court appears to lean towards Oregon City and complex homelessness case, and this is referring to the city of Grants Pass, Oregon v. Johnson. They had oral arguments going on, and oh boy, does it open just cans of worms all over the place, and opinions. Joined today by Dexter Tarbox, contributor for New England Take. Welcome back.
Hi, AJ. Nice to join you.
So you told me you got pages upon pages of notes when it comes to this, but I mean, let's start off with the bare bones. I mean, what are the laws that that brought this to court? 'Cause, I mean, there were two homeless people ultimately that were the plaintiffs on the case in front of SCOTUS. So I mean, this is getting down in the weeds.
Oh, yeah. So this was an anti-camping law that this town in Oregon was able to enact. And so one of the things that I think is interesting about Oregon is that it is a home rule state without any Dillon rule. So home rule means that the state, that the towns, the municipalities within the state, can essentially enact their own criminal laws, even. The Dillon, or laws in general. The Dillon rule further specifies that those laws need to be within the powers that the state legislature devolves to the cities, to the municipalities. But that doesn't exist in Oregon. So Oregon, this town, Grants Pass, was able to make its own law criminalizing camping, which they define as putting down bedding and sleeping overnight in public lands. So that's what the case comes down to. It's not regards to certain behaviors. It's not regards to putting up tents. It's not in regards to building fires. It's not in regards to public urination or defecation. This is specifically about what they define as camping. Again, sleeping on bedding overnight in a public space. So that's where this law comes from. And in a state like Oregon, they are empowered to pass these laws at the local level. And that's now risen, as you say, from these two cases all the way up to the Supreme Court.
And it seems like there's this nationwide trend. I mean, that's totally hit New England at this point, where we've moved beyond just the traditional. There's a homeless guy sleeping on the corner because he's had a rough. He's got a substance use disorder. He's got mental health issues, or he's just struck it bad when it comes to his situation in whatever way. Where we're literally seeing camps of hundreds of people set up. There was a camp of 150 people, 120 to 150 people pulled out. Concord Patch was reporting this week about a camp that was around the corner from where I live, where it's just trashed, where there's people literally setting up tents and creating little villages for them to exist in, or just in the corner of parking lots, literally setting up a camp. Like they have a tent, they have their whole seating and the whole 9 yards where they're existing, and then abandoning it. Usually, I mean, they're not, most of the time this stuff is not getting disposed of properly. It's a huge safety hazard for anyone around there physically. It's a safety hazard with regards to, you don't know the situation for these individuals that are now right outside your door now. This started, I mean, at least popular culture-wise, with what you're seeing in California, because it's warm, but I mean, it's all the way up here in Maine now even.
Oh, yeah, this is a massive problem that hits close to home in communities all across the country. And what's happened here in the case of Grants Pass is sort of exactly what you're saying here. The city has put forward the argument that there are massive public health and public safety risks to allowing homeless encampments to exist on public lands, in the public parks and areas like that. And of course, that's true. We can see it from our own experiences locally, that a lot of issues arise out of this. The question that they're raising, that the original plaintiff or appellants in the original court case were raising, is that banning people from sleeping, which they say is, of course, a natural human necessity, constitutes a cruel and unusual punishment under the Eighth Amendment. And that's really what the case comes down to. It's not whether or not the municipality has the right to regulate dangerous or destructive behavior, antisocial behavior. It's whether or not this is cruel and unusual because sleep is a necessity. And so that's what the question boils down to, even though, of course, it's something that we can all naturally understand. And they did take up questions over the course of the oral arguments, in this case, of mental illness, of drug addiction. But really what's interesting is that the parties for the government really seem to reject that line. They said that, and the justices pressed them rather hard on this. Why, for instance, is a person who is hungry, where eating is a human necessity, is barred from stealing food when they need it to live? It reaches that level of human necessity, whereas sleeping is something that needs to be permitted. And that's the line that the Supreme Court is trying to draw. Because the government is arguing that, of course, no, it is illegal to steal. We can't ban that, even though it feeds a human necessity when it's done, when someone is starving. But somehow they say that sleeping is different. Sleeping is a universal right that we ought to offer everyone, and that municipalities are not able to regulate where that practice takes place. But even there,
which doesn't make sense legally.
No, it's a completely incomprehensible line. And that's the issue.
I mean, they literally have
that's why I struggle
laws,
to describe it.
I believe this was brought up somewhere in the oral arguments too, where zoning laws exist for a reason. Like we already restrict where everyone can sleep as it is for every other portion of the population, except for this small isolated group, which are the most at risk, the most in danger by not being in a properly zoned place to live, where you're seeing, when talking about these camps, where rape is rampant, drug abuse is rampant, people with untold mental disorders are just going around causing violence to each other. We're having BB gun shootouts between each other here in Concord. Like, this is very much the only population where this is allowed to be the case.
Oh, yeah. And the government concedes that you can put regulations. For instance, they concede that you are allowed to prevent people from sleeping in the public right-of-way, in the street, because that has a traffic and a safety concern to it. But what the city of Grants Pass would say is that there are safety concerns associated with encampments as well. And the government, when they push back against this, cannot draw a coherent line between those two things. And so what they end up arguing is that homelessness is a class and not a behavior. That a person who is homeless is a member of a class, and under the decisions on a Supreme Court case called Robinson v. California, which was brought up in a lot of this, you can't legislate against a class. And therefore, you can't prevent them from doing this practice, but you can when there is a public safety involving the roads. Why that is, they can't articulate. But of course, this whole question, is homelessness a behavior or a class, is very controversial. It's one of the fundamental questions at issue in this case right now. And I think, as experience will tell anyone who's lived near or around any of these encampments or has dealt with the political or social issues relating to their presence there, that in the vast many, or at least in many cases, there are choices that are being made. In the case of Johnson herself, the named plaintiff in this case, she had a shelter bed available to her, which she did not want to take advantage of because they wouldn't permit her dog to stay at the shelter. Many cases, and I'd say the more frequent cases, are the fact that the shelter does not permit drug use on its facility. And many, many people do not want to abide by that rule. And so even though there are beds available, they opt to live in the encampments because it permits the behaviors that they choose they want. And so it's very hard to say that someone who's making a choice is a member of a class. It seems to me very clear that that is a behavior and not a class. And we can criminalize behavior.
This can get very messy very quickly as they start diving into, I mean, something that immediately raises red flags to me, especially considering my day job, is the standards for shelter beds and whether they have to use it, how many should be available, what's the threshold, who should be paying for it, is it the city's responsibility, is it the state's responsibility? I mean, if this decision is not clear that it's not addressing it or opening cans of worms with regards to it, things are going to get bad very quickly for many large cities and medium cities.
Oh, yes. And some of the conservative justices foresaw this. You can tell in the questions. I think it was Alito who brought up the point that if we are making this a determination of how many beds are available, et cetera, and we essentially constitutionalize this issue rather than making it an issue of state and local policy, again, depending on whether you have home rule, it's state or local. But federalizing this, and the phrase he actually used was, are we now to have the federal government, federal courts, superintend the Eighth Amendment as it relates to this issue? Worse, are we to have police officers superintend the applicability of the Eighth Amendment in this case? Are they to go out into the park and say, well, we have 5 shelter beds available and there are 6 homeless people here. One of them can't go in. So he has an Eighth Amendment right not to be ticketed. But because the other 7 or what have beds available to them, they can't. Then, of course, as we said earlier, there's the question of the suitability of the beds. If the person is rejecting them because they have a mental illness, which makes them incompatible with living in community, if they have an animal, if they have a drug addiction, which they're unwilling to give up, is it still an Eighth Amendment question? We're literally inviting now these officers to make judgments on constitutional questions if the arguments of the Johnson side of the case are to be accepted. That is a can of worms of massive proportions.
I despise the fact this even went to SCOTUS. The whole concept that this is going to the federal level with regards to a specific ordinances at a city level it just makes my head explode. Like this should have been going to that state Supreme Court and staying there, let them sort out their own policies. I don't want the Eighth Amendment involved in any bit of this. This is a hyper local issue where each state, they can screw up or fix whatever they want when it comes to it. If you're in California and you want to continue to have all your camps and everything like that, have at it. I think it's worse for your communities, but I don't want whatever happens in Grants Pass to have any impact on what we decide here in New Hampshire.
And this was a 2.5-hour long session of oral arguments. That's long. That's abnormally long. And I think it's because the lines that have to be drawn to constitutionalize, to federalize these issues are so complicated and ill-defined. I have to say, I don't think I've ever seen the government attorneys, it wasn't the Solicitor General in this case because it wasn't a federal issue, but be so ineffective in their arguments. I mean, they literally could not draw the line between, okay, let's say we have a statute locally, statewide, what have you, that prohibits, as they do in Oregon, public urination, defecation. Now, these are necessary natural functions, the same way that sleep and eating are. But the government concedes that those rules are acceptable against public urination and defecation. Those we can regulate, even though they're necessarily human behaviors. Why sleep can't be regulated in this way, they can't draw that line. They make broad attempts, but they're very ineffective. And a few of the justices got down to this issue, and I think that this may be why the government dances so much around this issue in the federal court, because they want to be able to continue to regulate drug use. And if we were to concede that is potentially an involuntary behavior, as a result of addiction, it falls under it falls under the same trap that they're trying to set for these laws, which is that criminalizing it is an Eighth Amendment violation. It is cruel and unusual to punish someone for engaging in an involuntary behavior, as they would say. And so if the government draws that line too close, the Supreme Court may well invalidate, or could well, it won't happen here, but could well invalidate the entire basis for the drug enforcement scheme in the country. So they have to straddle this very narrow line in making these arguments. And again, it just brings us into this morass of Eighth Amendment and federal government questions that never should have been invoked in a case like this, as you say.
It really bothers me, so I'm going to continue on this tangent. It's exactly the same thing as we saw with Obergefell and Roe, where each state has their own ways they want to handle it, and the Supreme Court's going to go in and make some executive decision that, in my opinion, they never should have. They shouldn't even have the right to be able to do. I mean, this whole advantage I thought of having a conservative court is we can finally avoid it, but unfortunately, guess what? There's courts that lead up to SCOTUS, and it's a day late and a dollar short, and I doubt SCOTUS is going to magically turn around any of that. But this is all public policy. Like, this is something the states should, or DC for that matter, in Congress, should be deciding what they want to do with regards to the laws on it. Like, this is a fundamental issue that has been in this country for more than 100 years, at least. I mean, put it in more traditional sense of homelessness. We're not talking about colonization days. We're talking about in country building days. We're talking about the country's established. We now have a population that's rising astronomically over the last 100 years. We got 327,000 homeless people estimated in the state according to the census. Like, we need public policy decisions that are actually going to make fixes instead of these. It really bothers me that there's all these organizations that are funding this, like, or were joined by the organizations advocating for these people: a National Homelessness Law Center, National Coalition for the Homelessness, Community Solutions. These people should be focused on finding solutions for housing, not supporting camping. Like, camping is not what anyone should be desiring in this. I don't care. So, heartless moment. I don't care if these individuals don't want to live in solid housing. I'm sorry. That's the conservative side of me coming out. I don't care because it's bad for everyone involved. Like, it's peak libertarianism. It should be a law if it's going to be a problem that's going to affect literally everybody else. Like, this is the epitome of that barrier.
And to argue that we can regulate people sleeping or sitting or encamping themselves in any way on the street because it's a public safety risk, but that it's not when they do it 15 feet away in the park seems an absurd argument to me.
Yeah, and we walk around Manchester the last couple of years, especially since COVID. I would hate to live in around any of these parks over there, because they're literally surrounded by people either sleeping on park benches or now with tents. I went to an event down a couple blocks from Elm Street in one of the residential areas, and I was having to keep an eye looking around because I've got cameras on me for recording video. I'm like, I don't feel comfortable walking around here at all as a adult guy. Like, you shouldn't feel that way just right in downtown of a city.
Oh yeah, I'm a larger sized person, and I lived in downtown Manchester for many years, and it is a worrisome place in many ways. And again, I think this does bring us back, though, at least when we're talking about cities like Manchester and Concord, to the initial point, which is our ability to pass local legislation on that. In New Hampshire and in Vermont, at least, out of the New England states, we really can't. These types of criminal penalties, like we're seeing in the Oregon case, I think they start as civil penalties. It's a ticket, and that can escalate to court. We really can't create that on the local level in these two states. And even in the other New England states where there is some level of home rule, they do have, as I said earlier, the Dillon rule, which says that their powers are only the powers that are delegated to them. They're not implicit, but the municipalities, but their powers are such as are delegated to them by the state. So unlike Oregon, which I think we can assume from listening to the arguments this law will stand, the Oregon law. We can't pass that here. We need action on the state level, especially, as I say, New Hampshire and Vermont, but really in all the New England states, to take the kind of action that we're seeing here to ban these encampments is not something that we can do on our local level.
Yeah, and they're too busy trying to deal with 1,700 bills this term too. So, good luck getting anything effective.
Well, nothing's going to be happening on this in the state legislature. Yeah, we have a large and busy legislature in New Hampshire.
All right, Dexter, make your predictions. How's the majority opinion going to rule here?
I think that the majority is going to rule that the law is enforceable. So they're going to reverse the lower court's ruling and allow Grants Pass to continue enforcing the law. And that will be on party lines.
Oh, yeah, this will definitely be a party line one. It will have some. If at most they get close, it's going to be a milquetoast. Oh, I disagree with you because of this, and this. Not necessarily because of the issue, but.
Oh, I mean, I think Sotomayor almost cried at one point during her questions. I mean, this is an emotional issue, I think, particularly for people on the liberal side. So, yeah, this will split right down party lines, no question.
NewEnglandTake.com. Like and subscribe if you're checking this out on YouTube. Be sure to follow us on social media. We're all over the place posting videos and clips and such. And I'm going to be playing around with YouTube Shorts now, so... comment. Is that a good idea? I don't know. We'll see if anyone watches.
TikTok before it's banned.
Before it's banned. Let's get it under the wire. I'm finally going to start using it right before the feds knock it out. All right. We'll talk to you soon.